The adopted DFCs, they allow for a continuing increase in the quantity of water that can be pumped. They provide some protection for existing users, in other words, the available drawdown in their wells, so they're still able to obtain the water, their water supply, and work and coexist with new pumping too. They were determined to be physically possible by the Texas Water Development Board based on the GAM simulations, and this occurred after August of 2010. They allow for permitting flexibility within the districts because you can have greater drawdown in some areas and less drawdown in other areas. The concentration of pumping is not the same all through a district, not the same through a county, so you need that flexibility. This results, as I said, in higher pumping amounts for various areas, and that already is occurring. That already is occurring within districts in the GMA. Now let's quantify a little here. This provides for reasonable developments of the state's groundwater resources, allows production in the Corrizo-Wilcox Aquifer to increase from the TWDB estimated about 83,000 acre-feet per year within the GMA to 257,485 acre-feet by 2060. The current pumping was as of 2008. So it allows for an increase in that aquifer, allows for additional pumping from the other relevant aquifers, and that's not included in this total right here. This amount of pumping slightly exceeds the estimates of groundwater availability within GMA 12 that will be in the 2012 state water plan. So we're a little higher than that estimate for the water plan. And it allows for the distribution of the pumping in areas, in new areas. There's no pre-approval or pre-denial of permit applications. This is an open process. There are going to be areas that need water, and there are going to be areas that do not need water. In summary, we performed this effort as required by House Bill 1763. Excuse me. They were developed in an open process with 13 GMA meetings at which there was allowance for public comment, public testimony, and stakeholder testimony. We received input from stakeholders having a widely varying perspective or perspectives. That was significant and was considered. Meeting the GCD obligations under state law required balancing these various interests and needs. We worked to evaluate the reasonable long-term use of the aquifers as a water supply, and we utilized the Texas Water Development Board, Queen City, Sparta, GAM for this effort. It was one of the things that was used. As I said previously, this accommodates 175,000 plus acre-feet per year of increase in pumping by 2060 above levels that were estimated in 2008. And the plus is because this does not include increases in pumping from the aquifers other than the Queen City, other than the Corrizo-Wilcox. DFC compliance is gauged using an average water level decline method. This same method is used in 12 of the 16 GMAs within the state. They can be quantified, the DFCs, and they can be measured using the average water level decline method. And that concludes my presentation. Thank you for your attention to what is being said.
Hello, my name is Monique Norman. I'm the attorney for the Brazos Valley Groundwater Conservation District and for the Fayette County Groundwater Conservation District, and have been for a long time now, way before the development of HB 1763, throughout the development of 1763 with the legislature, and going through this whole initial DSC process. GMA 12 cooperated and followed not only the letter of 1763, but also the spirit of it. The reason that legislation was put in place was because you had all these different groundwater districts by political boundaries throughout the state, but you had aquifers that didn't recognize political boundaries. Working with the legislature and the Water Development Board, the process was put in place so that you would have regional water planning, so that those districts would work together and work with the aquifers that are connected under them and have a regional water planning system. And then you have still the layer of local control where the groundwater districts would then individually regulate and have their permitting system. And that's what's happening today. In hearing some of the petitioners' issues with the DFCs, those are issues that are more pointed to a individual district and the regulation and not the DFC process. And I want to make sure, and I concur with what Mr. Lean said, that the petitioner here has the burden of proof that these DFCs are not reasonable. In my mind, and the lawyer for these districts, these DFCs are per se reasonable. They follow the law. They did everything that the law required and then some. They followed Chapter 36-108 and Chapter 356 of the Administrative Code, the Water Development Board rules. Both procedurally and substantively. They had, as was previously said, over 13 meetings where they took stakeholder comments and considered those. They had lots of hydrology meetings, lots of separate groundwater district meetings. All of those were far in excess of what was required by the law. They met the legal requirements of 36-108 and the correlated regulatory rules. They were required to consider and use the GAM, the groundwater availability models. They did extensively, working with the Water Development Board and their own hydrologists. They were required to look at the different aquifer conditions that differ from geographic area. They were required to look at the different uses per geographic area. They did all that. They considered heavily the regional water plan and that was then adopted in the state water plan. And their numbers, their availability numbers are significantly consistent with those numbers. The petitioner used the term reverse engineering kind of as a derogatory slam towards of how this process worked. But really, whatever you call it, they were following the law. I've heard Dr. Metz, Water Development Board, say many times, as many of you have, that water planning and groundwater planning is a marriage of policy and science together. The statute requires that marriage. It requires that you not only look at the aquifer conditions and the science and the GAMs, you have to look at the different uses, current uses and future uses. That's what this GMA did. They took it from the regional planning process, the state water plan, and the information that the local districts had, and did all those together. That's science plus policy, and that's the reality of water planning. They complained that this process was arbitrary. I don't know how it is possible that if you follow the law, by the letter of the law, you follow the science, you work closely with the Water Development Board, you follow the experts, foremost experts in the state in this field, it cannot possibly, in the state water plan, it cannot possibly be an arbitrary process. They would prefer a different methodology, and David talked about that, and we talked about that the Water Development Board has already previously stated that taking issue with how the groundwater availability models work is not the purpose of this process, and I agree with that. Total aquifer storage, total aquifer availability is not a required tool in groundwater joint planning. It's not required by 36-108, it's not mentioned in 36-108, it's not mentioned in 356. That also ignores the important policy part of of this process, in that you do, as I previously said, you do have to look closely at what the future needs, current and future needs of the area is. And looking to just at total aquifer storage, that ignores that fact. It ignores that districts are required in their permitting to consider the effect on existing wells. It ignores, their proposed methodology would ignore that and would not allow the districts then to follow the law in its entirety. Again, I'm not playing hydrologist, but as our hydrologists continuously point out to me, that even to do a total aquifer storage methodology, you still have to use the aquifer level information that we propose as our methodology in the DSCs, the water level decline methodology. To quickly recap, that's a commonly accepted methodology used by a majority of the groundwater districts in the state. It is quantifiable. You can measure it in existing wells. It is measurable. It protects existing wells. It is easily understandable by the stakeholders, and it puts into place a methodology that these districts, along with Water Development Board, have the current monitoring system. They will expand on that. They will develop future, and they can enforce on those. It's easily enforceable where those water levels are in the existing wells. It allows for adaptive management, which is what this DFC process is. The reason why you have to revisit this every 5 years is hopefully every 5 years we have new information, more wells monitoring, and better information on the use of the aquifers to revisit that. And this water level decline methodology will allow us to do that, and to get better and more informed DFCs as we go forward. Again, John and David did a good job of explaining the balances required in the Water Development Board review of socioeconomic impact. A major socioeconomic impact is what would the impact be if you did not meet the groundwater needs projected in those planning numbers. We consider that, obviously, since we are significantly consistent with those numbers. Obviously, we met the legislative and policy directive of this as we follow the law, which was the policy of the state and the legislature. The impact on private property rights is a two-sided coin. This DFCs allow for, I think, up to around 3 times the amount of current production. That's a lot of new production allowed over the next 50 years, but it also balances with some regulation by the district that in acknowledging the impact of private property rights, you also have to acknowledge the other side of that coin, that you protect people's rights of that water in place and allow for future use. The development of state groundwater resources, again, I firmly believe that when you're consistent with the state water plan, that is the state policy on groundwater development in the state, and we are consistent with those. Environmental impact, although John Seifert discuss those, and we will talk about those more with environmental stewardship petition next week. That was not an issue raised by the petitioner, obviously, as their aquifer storage method largely ignores environmental impact. And as was stated, by virtue of the GAMS working and the preliminary approval by the Water Development Board, these DSCs are physically possible. Therefore, with the district, the GMAs balanced all of those required statutory and followed the law and clearly met their burden in providing a reasonable DSC to the Water Development Board.